You ready?
Yes, sir.
May it please the Court, my name is Bill McCabe. I represent the claimant Anthony Villa. Seated at counsel table is Lloyd Basso, claimant's trial attorney. And I'd like to reserve 3 minutes for rebuttal. In this case, the claimant, who was a traveling employee, was severely injured while attempting to mount a horse at his friend's ranch. The judge of compensation claims found the claimant's injuries were not compensable because the activity of horseback riding is per se inherently dangerous and therefore not a reasonable activity for claimant to partake in. We submit the judge's error.
Isn't this case just like the Rigdon case?
No, ma'am. The Rigdon case, we submit, has many differences. First, Rigdon was decided under a law that really doesn't apply now. The law at the time of traveling employees, as cited by the cases and Rigdon, was an employee whose work entails travel away from the employer's premises is within the course of his employment at all times during the trip, other than when there is a distinct departure for non-essential personal errand. The current law, as first announced by this Court in the Garber case, is a traveling employee may indulge in any reasonable activity, and if he does so, the risk inherent in such activity is an incident of his employment.
That is the
So
law.
the test is reasonableness of the activity.
Reasonableness of the activity.
Sir.
That's the test.
The statute, in effect now, though, simply says that the traveling employee has to be in the course and scope of his or her employment. Isn't that what the legislature has told us?
Yes,
we have construed that as you accurately state, but this is a course and scope case, I think. These cases now are all course and scope
It's a
cases.
course and scope case, but you're in the course and scope of your employment if you're engaged in a reasonable activity. And the risks inherent in that activity are an incident of employment.
Well, assuming having dinner was reasonably related to the activity, how can you argue that mounting the horse afterward was? I mean, what did that have to do with the activity?
I can argue it for a number of reasons, but I do want to back up for a second. The judge did find that going to the Bazzini Ranch to have dinner was a reasonable activity.
Right.
Right. And then that next step, though, is mounting that horse.
Next step was mounting the horse or attempting to ride a horse a reasonable activity? And we submit it is. First of all, the employer in this case placed no restrictions on claimant or any other sales representatives as to any activities they engaged in while in travel status. And this employer, you know, they had some of their own meetings where they one time did, it was team building, but they did activities like Navy SEAL training. Secondly, the Bazzini Ranch was located 20 miles from Ocala, an area well known for horses, and an area where horseback riding is a reasonable form of recreation. If you were stuck in Vail, skiing is probably a reasonable recreation.
Well, that argument doesn't help you that much in light of the Rigdon case.
Well, there's another case, though, from Wisconsin that, but it found that skiing was a reasonable activity.
Well, I think, I was thinking about this as I reread the briefs last night, which is that if they were having a drug rep conference at a ski resort or at, say, the Homestead in West Virginia, they have horses, your argument would be a little different, but the fact that you are 90 miles from your hotel and your hotel is not located in the area where the horses are.
Well, keep in mind, the judge found that where he was was reasonable, and that wasn't cross-appealed. So he's at a place where he was expected to be, or not expected to be necessarily, but which was reasonable.
But his activity can come in and out of reasonableness. It's not just that he was at a place where it was reasonable. It's the actions that he took when he was there that may render his activity unreasonable.
Well, and I'm trying to explain why it is reasonable, because, like I say...
I know, but what you keep saying is it was reasonable for him to be at that place for dinner. We're beyond that.
Okay, right. Reasonable to go horseback riding because, A, no restrictions. B, in Ocala, where horseback riding is a reasonable form of recreation. C, he was at a ranch of friends of his who owned 6 horses and who took people horseback riding. Nobody had ever been injured on that.
I'm real familiar with the cases, particularly the Hout case, but I'm just not sure that our use of the word reasonable in that case means the same thing it means in the standard jury instructions in negligence cases. Doesn't the reasonableness have to take into account what the employer might have contemplated that an employee would do. And let me give you, for instance, going back to the Houck case. Assuming that Judge Hill was correct, that he was within the course and scope when he went to the friend's house for dinner, had he stopped off on the way back to the hotel to go dancing, for instance, or to stop off and maybe have some dessert and had been hit in the parking lot, we know, unless Houck has wrongly decided, that that would not have been in the course and scope. Right?
Well, in Houck, they found that the claimant was not a traveling employee.
See, I don't think that makes any difference under the new legislative formulation. I think what you've got is a course and scope test, which is broadened for a traveling employee somewhat because of our case law talking about reasonableness and all that sort of stuff. That's the way I see this, just to let you know.
Well, let me, if I may, go on about why the activity is reasonable. The horse that this gentleman was going to ride, children have ridden that horse. People bring ponies to children's birthday parties. Is it unreasonable for somebody to put their child on a pony at a birthday party? I mean, that's basically what this decision is saying, is that it was unreasonable for a grown man to get on a horse. The basis of the judge's ruling, and the judge really makes a finding as a matter of law in this case. The judge finds that it was not reasonably foreseeable that claimant would engage in what is per se inherently dangerous activity, which requires by statute that signs be posted around the area. Now, there's nothing in the statute that says horseback riding is a per se inherently dangerous activity. The statute does discuss.
But that's a factual issue for the judge to make a determination on, isn't it?
I'm sorry?
It's a factual issue for the judge to determine.
But, you know, the judge never makes a factual. The judge doesn't get to a factual issue. The judge finds basically as a matter of law, because of that statute, that horseback riding is not a reasonable activity. Could never be a reasonable activity based on the judge's ruling.
Well, does the reasonableness have to do with the relationship between the activity and the mission of the traveling employee? And this would be a much better case for you, I think, if the traveling employee, your client, was in a business related to horses or animals or equipment for horses or animals or something. If he was trying to perhaps woo a customer, let's say, by riding the horse with the customer. But this was completely unconnected with the employee.
So is going swimming by an airline stewardess. So is playing
Well,
basketball by an airline stewardess.
where do you draw the line on that stuff, though? I mean, what if they decide to go bungee jumping after dinner? I mean, you know, where do you draw the line? I mean, the reasonableness doesn't it have to have some? I mean, wouldn't we logically think it has some bearing on what this employee does?
Well, the cases don't say that. They really don't. It's just, is it a reasonable, I mean, you can engage in recreation if you're a traveling employee. So the question is what is reasonable recreation?
So your position would be the same if your client had not gone horseback riding but had gone bungee jumping?
No, I'm not saying that. I'm not saying that. But I'm saying horseback riding is not an unreasonable activity, particularly under the circumstances of this case. And if I can get to that statute, the statute doesn't say it's inherently dangerous. It does discuss inherent risks of horseback riding, and it gives an equine owner the opportunity to not be liable for injuries on a horse if they post a sign. If they don't post a sign, then they're not absolved of liability, and the injured person can sue them under common law.
What is our scope of review of a determination of reasonableness by the by the JCC?
In this case, I think your scope of review is de novo.
That's a classic question of fact in civil practice.
Well, the reason I say that it's de novo, and we'll go back to Houck. Houck says this case involves the application of undisputed facts to the law. Such cases are reviewed de novo. And then there was a federal case interpreting the Florida Workers' Compensation statute that involved vicarious liability of an employer because of the acts of their employee. But it stated under unrefuted facts whether a person is in the course and scope of their employment is a question of law. So I would submit that your standard of review is de novo. Now, going on again back to this statute.
Well, if it's de novo, then this is truly going to revert back to a case-by-case analysis, because this court will have to decide whether 092 sub 4 applies in every case. We don't even need a JCC decision unless they're disputed.
Well, if the facts are undisputed. I mean, a lot of times you have dispute.
Even on, well, I'm just suggesting to you, and again, I have reference to civil practice. Even on undisputed facts, the question of reasonableness is generally viewed as a classic question of fact.
Well, if it is a question of fact, then I'd submit that there's no competent substantial evidence to support it. Because, you know, first of all, there's no testimony that horseback riding is inherently dangerous. The statute doesn't say it, and as I was saying before, the statute, all it does is give a horse owner the ability to not be liable for injuries that somebody sustains on one of their horses if they post the sign. If not, you go back to common law. And interestingly, under common law, in order to prevail against a horse owner, you have to show, number one, that the horse was known somehow for had exhibited those propensities in the past, and the horse owner knew it.
I don't mind exposing to you my view. My view is, and I appreciate the way this case was litigated, but I think that's all just sort of lagniappe on top of this case, to tell you the truth. The question is course and scope, and whether or not riding a horse broke that, that's the issue, I think.
It is the issue, but the answer is if the activity is a reasonable activity.
Well, I'm thinking of the area of the state where this arose, and, you know, I don't think it's too outrageous to suggest, what if this guy was like a lot of us and say he was a trout fisherman and he wants to go over to the Mosquito Lagoon, Banana River or something, and cast for a few trout just a few miles away, and he gets eaten by an alligator? I mean, where does it...
Well, that gets to the question, is fishing a reasonable
activity? And we'd have to decide that, though. See, that's what I'm trying to get at.
Well, the court's determined swimming is a reasonable activity. It has...
Swimming where?
Swimming in pools.
What pool?
Okay.
That's what we're talking about. Even the YMCA basketball is provided indirectly by the employer.
Okay. But that is the location, and the judge has already found that the location that this claimant was at was reasonable. So, yes, the swimming was at the pool of the hotel. It was reasonable for the claimant to be there. And swimming pools have signs, warning signs. But the claimant that was injured diving in a swimming pool, her injuries were compensable. I guess I just want to touch on my second point, so I have a shot at it, is the minimum deviation. If you feel that horseback riding is an unreasonable activity, this claimant, there was a minimum deviation from his employment. He got injured while attempting to mount the horse. There's a number of cases that hold that if you're in the course and scope of employment, which this claimant was at the ranch, and your injuries occur during an insubstantial deviation, it's still compensable. This was an insubstantial deviation. He was injured as he was attempting to get on the horse. It couldn't have taken but a matter of seconds. So the accident is still compensable for that reason. And I'll reserve the rest of my time for rebuttal. Thank
you. May it please the Court, my name is Bill Rogner, and I represent the employer in this case. Your Honors, their appeal is based on a central premise that the JCC could not find as a factual matter that going horseback riding with a friend 90 miles away from the hotel was unreasonable. And, Your Honors, you've alluded to it, particularly you, Judge Padovano. It's not just about reasonable. There's two things here. It has to be foreseeable and reasonable. Foreseeable and reasonable. The backdrop of the analysis is this. A traveling employee, when a traveling employee is required by the employment to stay in a particular place, he may engage in all reasonable activities at that place. That's Garver and Houck. And then to analyze the injury itself, we ask, did the injury arise out of a risk reasonably incidental to the conditions and circumstances of the employment? And the swimming pool case you mentioned, Judge Kahn, it's a swimming pool at the hotel where the claimant is staying. It's foreseeable by the employer that the claimant would use the pool. It's reasonable that the claimant would choose to use the pool. The exercise case you mentioned, Judge Kahn, it was a YMCA, all the case says is closely located to the hotel. It's reasonable to expect that an employee on a layover is going to attend to health issues, to exercise. That's why that's foreseeable, and that's why that's reasonable. In this case, the employer did not know, nor had any reason to know, that this employee would travel 36 miles in the wrong direction from his last business meeting and 90 miles from the hotel to go horseback riding. They had no reason to expect that. It was completely unforeseeable. And Judge Kahn, you mentioned the whole inherently dangerous. It's completely meaningless. That statute doesn't apply here. I don't think it needs to apply here in order to get the same result. That's really not the question about whether it's inherently dangerous per se or not. The question is whether it was foreseeable that he would do it and whether it's reasonable in the employment context that he would do it. It's not unreasonable to go ride a horse. I've ridden horses, but it has nothing to do with my job. Judge Padovano, you mentioned a possible scenario where it would be compensable, and I agree with you. If, for example, Mr. Bazzini, who owned the farm, was a physician who might purchase the pharmaceutical sold by Astellas, and the claimant goes to see Mr. Bazzini to discuss purchasing pharmaceuticals, and Mr. Bazzini suggests, why don't we go out and ride horses and talk about it? That would be covered. That's business. That's business. That's related to the work. It's related to the industry. What the Supreme Court has told us about the purpose of workers' comp, it's remedial legislation, and its fundamental purpose is to relieve society of the burden for caring for injured workers by placing the burden on the industry that creates the risk of the injury. Astellas is a pharmaceutical company. They didn't create the risk of this injury. They did not ask him to stay in Ocala. He was going to stay in Orlando. The northern edge of his territory was the Villages. He went 36 miles north of that. He got done with his last meeting, didn't go back to Orlando where he's going to stay. He went 36 miles in the opposite direction. And Mr. McCabe also tries to characterize this as a momentary, instantaneous deviation that was planned 3 weeks in advance. He talked to his friends, the Bazzinis. According to Mr. Bazzini, quote,
I think he may be, and he can clear this up, but I think what he may be focusing on there in his second point as a deviation is the actual misstep in getting on the horse. I'm not sure about that.
Right. I think he is. I think he's saying, look, this was a momentary or instantaneous deviation because it happened right at the beginning of it. And I assert that that analysis is flawed for a couple of reasons. Number one, it began 3 weeks earlier when he planned it with his friend. Okay? This is not the firecracker case. Okay? The guy's in a break room, and by the way, that was a case that all of us still on the defense side shake our heads at. But the guy's in the break room and decides it might be funny or entertaining to light a firecracker and blows up in his hand. And that was an instantaneous deviation that did not result in a denial of the case. But there were lots of reasons for that. Number one, he was still at work. He was on the premises. He was on the clock. And what he did lasted literally seconds. And so Mr. McCabe seizes on this, it lasted only seconds. Okay? But it only lasted seconds because he was involved in attempted horseback riding. He failed in his attempt to ride the horse. Had he succeeded, it would have lasted for as long as he chose to be on the horse. So his analysis results in an absurdity in the way that the law would be applied. We take the same facts, except the claimant, not injured at the time he gets on the horse or tries to get on the horse, but he's injured 45 minutes later when a snake causes the horse to rear up. Okay? That guy, that's not instantaneous. It's not momentary. He's an hour and a half into it, so he gets no workers' comp. Okay? This guy, because he was unsuccessful in even getting on the horse, is entitled to workers' comp. That doesn't make any sense.
What do you think was the legislative intent when they redid the statute and used only language of course and scope of employment?
Well, what I think they intended was to eliminate all of these sort of side diversions, these things people do on their own, You decide, for example, that, you want to go dancing or you want to go to a restaurant that's 25 miles away when you got a free meal at the hotel, or you want to go visit a friend. We had the one case, Garver. In Garver, the claimant goes 20 miles away to go visit a friend and not to go bungee jumping or, rock climbing or some inherently dangerous thing, but just to go visit a friend. And this court found that was compensable. Maybe there are several other examples I could give you of these cases, but I think what the legislature wanted you to rule was that, look, if it isn't work-related in some way, it shouldn't be covered. And that's kind of reflected in the Houck case. Now, Mr. McCabe says the court found that she wasn't a traveling employee at the time of her death. That's true. They found that she was a traveling employee when she traveled down there.
Well, if I can try to obfuscate further, I think what we meant to say was that once you get out of course and scope of employment, you're not under the traveling employee statute, although you might come back into it.
I agree, and that's exactly what happened in Houck, okay? In Houck, we have a lady that she's going to start her week-long project on Monday, okay? She's allowed by her employer to go early if she wants. They pay for her airfare, and they give her an employer-owned apartment to live in. So instead of reporting on Monday for work, she would actually going to have to fly down Sunday night to be ready Monday morning, okay? Instead, she goes down on Saturday. Employer pays for the airfare, okay? She goes from the airport to the employer-provided apartment. Covered, right? Then she goes to meet this manager she's going to be training and has dinner and talks about work. And in fact, this court said in that case, all right, maybe at all of that time she was covered, okay? But after that, what does she do? She goes window shopping and then dancing and then comes out of the club at 2 o'clock in the morning and is hit by a car. Okay? And this court found she was not in the course and scope at the moment of her injury. Because this has nothing to do with her employment. She has severed the connection between her employment and her activity when she chooses to do something that is purely personal and for her own enjoyment. And, Judge Clark, you mentioned Rigdon, and that case has never been overruled. In fact, it's still cited. It's been cited multiple times in a favorable manner, but that's the flight attendant who gets injured skiing 58 miles away from the hotel. And this court describes it as a private mission designed strictly as an amusement venture bearing little relation to his normal creature comforts and necessities. Okay? That's exactly what this is. He did not go to the Bazzini farm to eat dinner. Yes, he was going to eat a meal when he went there, but that's not why he went. He didn't show up with steaks for the grill or a bottle of wine. He showed up with boots and jeans to go riding. That's why he went. And he was injured doing that activity. And he was doing that activity 90 miles away from the employer-provided residence. Mr. McCabe mentions we didn't cross-appeal anything. Well, we won. The judge found that it was not a compensable claim. Had the judge ruled it was a compensable claim, I would challenge the reasonableness of him being 90 miles away. I don't think it is reasonable for him to travel 90 miles away from the hotel to get a meal. I live in Orlando. There are hundreds, maybe even thousands of dining options. The employer in this case reimbursed him for his meal expenses. So he could choose to eat in a hotel. He could choose to eat at the restaurants that are around the hotel. Maybe he could travel several miles within the urban area of Orlando to find a restaurant to eat, to be reimbursed. But I don't accept that it's reasonable for him to drive 90 miles to go get a steak. And again, that's not why he did it. Your Honors, we think this case should be analyzed as a course and scope case. Was he in the course and scope at the moment this happened?
What about I didn't ask you this question, I apologize for interrupting you, but what about the scope of our review, the standard of review actually is the question.
Okay. Mr. McCabe seized on that sentence that's in the Howe case, but I completely disagree that the standard of review in this case is de novo. Okay? What have we been talking about for the past 25 minutes? We've been talking about the facts. The fact that the facts aren't really in dispute doesn't make it immediately a de novo review. Because the question is, can the judge apply these facts? Were there sufficient facts for this judge at the trial level to conclude that this was an unreasonable, unforeseeable activity for this employee to partake in? It's clear to me that review is CSE. It's CSE. And we think that the record is certainly sufficient to withstand that standard of review. And we hope that you'll affirm the decision. If there are any further questions?
Thank you.
Thank you.
The Houck case is clearly distinguishable because in Houck, the claimant never was a traveling employee in the first place up to the time the accident happened. She went early to her place of employment.
See, I don't get it. I've been on this court, as you know, for 20 years and have seen the evolution of Chapter 440. But it seems to me like what the legislature has tried to do is to say it's course and scope of employment. And the traveling employee statute is still there for some reason, and I guess that's to give a court the leeway to say, well, you know, you get meals and mileage. But it's course and scope, it seems like to me.
Well, the reason the traveling employee statute is there is because you got an employee who's taking out of his home. He's set off somewhere else, and he's got to stay there. And the court says you don't expect the traveling employee to just sit there and
twiddle his thumbs. Then why did they say course of employment while he or she is actively engaged in the duties of employment?
Because here's the answer to that in Houck again. It says the test as to whether a specific activity is considered to be within the course or the scope of employment or purely personal is the reasonableness of the activity. Furthermore, a traveling employee may satisfy physical needs, including relaxation. Now, I just heard Mr. Rogner tell you that it's not unreasonable to ride horses.
So you're kind of going back to the test is reasonableness.
It's reasonableness.
And it's up to the judge to determine whether or not the activity was reasonable.
But the judge in this case didn't do it as a matter of fact. She did it as a matter of law. And as I said, Mr. Rogner says it's reasonable to ride a horse. So if he admits it's a reasonable activity, then why isn't the injury in this case compensable?
Maybe because going back to Garver, which is arguably a case that's favorable to the employee, it talks about reasonableness of the activity in terms of the risk that was foreseeable by the conditions and circumstances of employment. I think we've gotten away from that is what I'm trying to say.
And then let me get back to that one more time. I know my time's up, but you're asking for a dividing line. How about the employer set one? The employer had no dividing line here, none, zero. Thank you.
Thank you very much. As I said, we'll take a 5-minute comfort break, come back, and we'll hear the Miami-Dade cases.